Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Day before yesterday, Honorable High Court of Andhra Pradesh, Honorable Justice D.V.S.S. Somayajulu, actually, he has given a glittering judgment that rowdy sheets cannot be opened. Rowdy sheets cannot be closed. Of course, should be closed. Rowdy sheets cannot be opened against persons under the name of surveillance, and it infringes upon the personal liberty of each and everybody. చాలా ముఖ్యమైన విషయం. సో రౌడీ షీట్లు ఎవరికి పడితే వాళ్ళకి ఓపెన్ చేయకూడదు. ఈ సందర్భంగా గతంలో నేను వీడియో కూడా చేస్తున్నాను, హౌ రౌడీ షీట్స్ ఆర్ ఓపెన్. సో ప్లీజ్ రిమెంబర్, యాజ్ పర్ ది పోలీస్ స్టేటింగ్ ఆర్డర్స్ ఆర్ APPM ఆర్డర్ నెంబర్ 601. So persons who are involved in the case of breaches of peace, then rowdy sheets can be opened against them, and they have to be maintained for a minimum period of 1 year. This is the rule. But before the Honorable Court, GVSS Somayajulu garu court mundu, hundreds of WPs, writ petitions have been filed. One such is Rt.To versus State of Andhra Pradesh. So the decision was given in WP number, so this Suresh number is 21,247 by 2022, and the Honorable Court disposed it on 15/7/2022. So it's a very, very significant judgment, useful for the advocates. The judgment says, opening up rowdy sheet to brand the persons as rowdies, number one, and collection of his photos, displaying them in a rogues gallery, right? And whenever the new SH comes, summoning them to the police station or making them wait for days together, and think like that, they amount to violation of or infringement of right to privacy. You might have understood, right? So please remember, normally what does police say? Police say that as per the standing orders of the APPM, yes, which is prepared as per the law or existing at the time. Definitely the police are authorized to keep surveillance over the criminals. So therefore, in order to keep surveillance, we are monitoring their movements, and we are authorized as per APPM. But Honorable Court declared that your police standing orders do not qualify as a law, because as per Article 21, without sanction of law, the police cannot restrict the movements of a person, and you cannot collect the personal information of the persons, and also conducting home visits, and also raising up them during the odd hours. It is against to right to privacy, right to life and liberty, right? So in this connection, many WPs have been filed regarding questioning the opening and continuance of the rowdy sheets by the police. So in this connection, the judgment of ADHAR, that is Puttaswamy versus Union of India 2017, is a very landmark judgment. So దాంట్లో చెప్పింది ఏంటి? Privacy is the fundamental right under Article 21. Of course, it can be restricted only in accordance with law. So that's why the Honorable Court has also suggested, suppose if you say that you are keeping surveillance, make a law regarding surveillance. What are the methods you have to adopt? So like that, if you want to keep a track of the movements of the persons, make a law. That's why article, in order to, please remember, the privacy can be restricted only as per law. Some law should be made, but you can't say PSO. PSO, they are only mere departmental instructions, and they do not have any statutory backing. It's not a law, statutory backing, and they cannot be called law. So therefore, the direction is all rowdy sheets should be closed immediately. So normally, you may be knowing, another issue has also come. Whenever some opposition party, they wanted to lead some visit to some place, or they want to lead dharna, or they want to go to participate in some agitative action, the police, using their powers under section 149 of the CRPC, they will house arrest them. This is also not correct. So you have to give reasons. No doubt, under 149 CRPC, police are there to prevent any cognizable offense. No doubt for that you have. But for keeping good behavior or for rescinding these people doing like that, likewise 109, 106, 111, you can use the powers by producing them before the executive magistrate, not by taking the law into your own hands. Therefore, the suggestion is the state should make a law or enact a law on the surveillance, security and good behavior. Right? Very recently, normally, we'll be under the question, why can't we take the fingerprints, why can't we take the photos? So, latest Amendment Act, Criminal Law Amendment Act, identification. This is, I think, 2022 itself it has come. So, it is very clear that you can take the photos, you can take the fingerprints, you can take the DNA. Previously, we used to have the recourse of the so-called Identification of Prisoners Act. Now, that has been amended. Actually, this is the extent of the Amendment Act. Really. The court actually, the judgment started reading like this. So, your freedom ends where my nose begins. Your freedom ends where my nose begins. What is this? You may not be able to understand. That's why I brought the last point. తెలుగులో చెప్తాను. ఒక మనిషి తనకున్న చేతులు, రెండు చేతులు, ఏదో పుష్ప డైలాగ్ లాగా ఆయన అల్లు అర్జున్ చెప్తాడు కదా, కిందది నా కాలే, పైది నా కాలే, నా కాలు మీద నా కాలు పెట్టుకుని నీకు ఇబ్బంది ఏంటి అన్నాడు. దట్ ఇట్ డజంట్, అదేంటి మర్యాద గౌరవానికి సంబంధించిన వ్యవహారం. పెద్ద మనుషులు వచ్చినప్పుడు రెండు కాళ్ళు పక్క పక్కన పెట్టుకుంటాం, అది ఆచారం. సో అది ఆయన గురించి, దీనిలో డైలాగ్ అనమాట. అలాగే ఇక్కడ ఈయన రెండు చేతులు ఉన్నాయి కదా అని ఇంత పొడుగున ఇలా వెళుతూ ఉన్నాడు. వెళుతూ ఉన్నప్పుడు ఎదుటి మనిషికి, ఎదుటి వెళ్ళేవాడికి ముక్కుకు తగలబోయింది. దెన్ దెర్ వాజ్ ఎ ఫ్రిక్షన్ బిట్వీన్ దెమ్. ఇతను ఏమంటాడు, ఎస్ ఐ హావ్ గాట్ ద లిబర్టీ, ఫ్రీడమ్ ఆఫ్ మూమెంట్, నేను ఇంతవరకు పెట్టుకోవచ్చును. కానీ అదర్ సైడ్ అన్నాడు, అయ్యా యువర్ ఫ్రీడమ్ ఎండ్స్ వేర్ మై నోస్ బిగిన్స్, నా ముక్కు తేలిందంటే నీ తాట తీస్తాను. సో కాబట్టి ప్లీజ్ రిమెంబర్, దే షుడ్ బి రీజనబుల్ రిస్ట్రిక్షన్స్. So here in this judgment, the important points are: number one, the court said that the police standing orders, they are not law. That's very important. Normally, even I was under the impression that they were made according to law. But here, as per puttaswamy judgment, yes, definitely reasonable restrictions should be there as per law. So better the police or the state enact a law on surveillance, security and good behavior. It's enough. Then nobody can touch you. So this is a suggestion, indirect suggestion by the Honorable Court. That too, a practical man, DVSS Somayajulu, you may not be knowing, his father Dubur Subarao was very famous lawyer in Visakhapatnam. He worked as Cricket Board of India లో ఆయన పెద్ద ఎదిగి ఉన్నాడు, మున్సిపల్ చైర్మన్గా చేశాడు. ఈయన కూడా సోమయాజులు గారు కూడా అడ్వకేట్గా చేసి అడ్వకేట్ నుంచి హైకోర్టు జడ్జి అయినట్టున్నాడు ఆయన. ప్రాక్టికల్ మ్యాన్. కాబట్టి ఇలాంటి జడ్జ్మెంట్స్ మనం జాగ్రత్తగా చూసుకోవాలి. సో ప్లీజ్ రీడ్ ద జడ్జ్మెంట్ అండ్ ఎన్రిచ్ యువర్ లీగల్ నాలెడ్జ్. థ్యాంక్ యూ వెరీ మచ్.